and I do have a tendency to speak up just because that's my style, but I'll try to be as conversational as possible.
Okay. We're good. We're good. Whenever you're ready.
Morning, George.
Good morning, Brian. Yeah, I'm here with Bryan Dunklin, George Roddy here. Brian, part of the Flip That Contract is the module series, and what we want these wholesalers to have is some type of entity or identity, you know, from a legal perspective. And so I appreciate you coming here and educating us on the different options. And so I guess this presentation is going to be about an hour.
That's correct.
And we'll cut this thing up into 4 or 5 parts. So again, thanks for coming here, and you've got the floor, Brian.
Thank you for having me.
Yeah.
This is a presentation in which I'm going to be talking about the various issues associated with how you buy a piece of property and in what name you take the property and how you operate the property. And we're going to be talking about issues related to taxes and limited liability, but we're also going to talk about the very practical issues such as financing. We're going to talk about issues like what it costs to set it up, legal fees, accounting fees, the actual out-of-pocket expenses associated with operating an entity. And then we're going to talk about the benefits as well as the costs.
It's not free?
It's not free,
Okay,
but we'll talk about some free options and what those options are.
Okay.
Very quickly, as I'm told that every lawyer, give him a chance, and he's going to always start with his resume. So I'm going to do that to establish my authority very quickly, and I'll race through this since you all have it on the PowerPoint. My name is Bryan Dunklin. I served on the faculty at SMU for 23 years, where I taught real estate law and real estate transactions. I chaired the 820 Real Estate Lawyer Dallas Bar Association back in 2004. I think they're up to 950 lawyers at this point. I was formerly a general counsel of a national bank and also served as the president and general counsel of a real estate brokerage, syndication management firm. I've been practicing law in the Dallas area for more than 30 years, and I was also a real estate broker for more than 20 years. I'm not presently a Texas real estate broker. I got my my undergraduate degree from Southern Methodist University, where I graduated with honors. Then I went on to get an MBA and my law degree, and I'm pleased to say I was selected to the law review on the basis of my standing in my class in law school. And then I've also gone on to coach some of the SMU teams that have competed before the American Bar Association and have been selected as an honorary member of the Board of Advocates at SMU. I regularly give speeches to state bar functions, including the Baylor School of Law just this past May, Texas Bar webinars, which I gave last year. I spoke to the Texas Bar Advanced Real Estate Law course, the Mortgage Lending Institute, the Texas Land Title Institute, Texas Mortgage Bankers Association, and various other entities, including the Dallas Bar Association Real Property section in December. And I will be speaking this coming December to the Dallas Bar Association Real Property section on series LLCs, which is one of the topics that we're going to cover later today. I also speak to numerous real estate investor groups, including the previous session that you all had for Flip That Contract.
Right.
And enjoyed doing that.
Yeah, that's great.
I have to, as all lawyers do, give the disclaimer that these materials that I'm going to talk about today are for general educational purposes only, because the law is constantly changing. So I can't even guarantee you that what I'm telling you today will be either accurate or current. We just got out of a state legislative session. And of course, no attorney-client relationship is established by me presenting these materials, and you're advised to consult an attorney with respect to your specific circumstances. Now, here's what we're going to talk about, and these are the various choices that you have when you go out and think about investing in real estate. And I'm going to go through some of these in great detail, and others I'm just going to very barely touch on them. And George, I know you're interested in using trusts as a vehicle for taking title, and I'm going to have some comments about trusts, though I don't have it listed here. It's a topic in and of itself, but I'll give some general thoughts about the use of trusts. The way in which many investors start is simply by taking title in their own name. And so I'm going to start with that, but I'm going to go through the various factors with respect to each choice, and these factors are issues related to the limited liability or the extent of the liability of the individuals who will be owning and operating the real estate using these various entities. I'm going to talk about some tax considerations, and I can't possibly cover everything, but there are some important tax issues that I think are critical, if for no other reason than one of the two things that we recognize is a certainty is taxes along with death. And so understanding the tax considerations and factors to me is critical in your selection of the entity. We're also going to talk about certain non-tax costs of operating and forming the various entities, including filing fees, attorney's fees, CPA fees for tax returns, and importantly, I'm going to mention to some extent issues related to financing and insurance costs. Out-of-pocket costs are, in my opinion, a lot more important than fairly rarely encountered issues, legal issues like limited liability. And understanding the financing and insurance costs and the other issues like filing fees and attorney's fees, these are real out-of-pocket costs, as are tax considerations. Then we're also going to talk about the ability to raise equity capital and how you would control and or operate these entities with respect to the authority of someone to act, etc. All right, first thing we're going to talk about is the sole proprietorship. This is where you take the title in your own individual legal name. You can go out and file an assumed name, but the law in Texas requires that if you're going to use a name other than the legal name that you yourself have, you must file an assumed name certificate in the county where you are doing business, and at least where your principal county of business is. Most real estate investors who are going to operate in Collin, Dallas, Denton, Tarrant County are typically going to go ahead and file assumed names in those counties where they're going to have property operated.
You recommend, not to interject, but you recommend, because I've done it in one county, and that's really where my primary backyard is, but would it be your suggestion to go ahead and do it at all the surrounding counties?
The reason I would suggest that you do it, technically to get a bank account, you're going to have to at least have one assumed name filed in the county where the bank account that you're operating is located.
Okay.
But the argument can be made that you have a duty to give an assumed name wherever you're operating that business. So if you go out and buy a piece of property in Tarrant County, yes, I recommend that you go ahead and file your assumed name in Tarrant County. I think the theory of the law is a good one, and that is that if you're doing business as George's Real Estate, then George's Real Estate isn't a legal entity, and they need to be able to tie George's Real Estate to some legal entity. And if George Roddy Jr. is doing business as George's Real Estate, then you ought to have an assumed name that tells the world that that's who that is, that it's in fact yours. Now, even though you have unlimited liability as the individual owner, there's some things that you can do that we talked about at the seminar for Flip That Contract that you can put right into your contract to limit your liability. It's contractually limiting your liability. You can use a right to terminate your contract during a due diligence period. That's paragraph 23 of the Texas Real Estate Commission contract forms. Check the box. Remember to give the actual cash that's recited to the seller, because the paragraph says you don't give them the money or you leave blanks filled in and it doesn't apply.
Gotcha.
And don't forget to docket the number of days that you have to terminate the contract, and then follow what the contract says in terms of terminating that contract. But that's one of the ways you can tie up a piece of property, limit your liability, and be able to get even your earnest money back if you give the proper notice to terminate your contract before the end of that deadline that you're going to fill in paragraph 23. You can also use contractual provisions to limit your liability on the contract in paragraph 15. That's the default provision. And I regularly counsel my clients who are buyers to strike through the entire second line of that paragraph 15 default, and that will eliminate the right of the seller to sue you for specific performance or for damages, and that will leave the seller with the sole remedy of retaining the earnest money and now you've limited your liability to whatever you can negotiate as the earnest money.
Okay.
Then, as you know, we've talked about this at some length, it's very important to have a provision in your contract that allows you to assign your contract just in case you can't perform it. Maybe you can find somebody else who will.
Right.
And you want a provision in your contract that says if the person to whom you assign the contract who agrees to assume the responsibilities of the contract, that that's going to release you as the original party to the contract as the assignor, but only if you get an agreement from the assignee that they will agree to assume it. And then I use an Exhibit 1 that identifies these additional rights that you want to use, and those are available to get from me. I've got my contact information on this, so if you need to contact me, the best email for me is texaslaw@email.com.
And that was on the first slide.
That's on the first slide, and it'll be on the last slide,
Okay.
just like it sounds, TEXASLAW@email.com. I'm $250 an hour, and I bill in increments of 1/10 of an hour. And we do accept Visa and MasterCard and
PayPal.
Discover Card and PayPal, sure. Why not? Now, the sole proprietor is going to file a Schedule C or a Schedule E on their 1040 form. And once again, they're not going to have any limits on their liability. That's the principal limitation of using a sole proprietorship. But there's no cost to create it or operate it other than the preparation of your income tax return and the filing fee for assumed name certificate in the county of your principal place of business or wherever you're operating your property are nominal. I mean, they're typically $20 and they last 10 years.
Right.
And you can Google in your county the county clerk, so the Dallas County Clerk will have a link to assumed names. You can download the form, complete it, mail it in with your check, and you've got your assumed name and you're ready to do business. Bank accounts in the name of the assumed name, and you can take a deed in the name of the assumed name. But the principal benefits of the sole proprietorship may come from how easy it is to control and the logistics. It's just you. You just sign your name. And even though you've got unlimited liability, unless you contractually limit it, it's easy and inexpensive to operate. By the way, there are some tax benefits that are associated with the operation of a property, particularly a residential property. And there's $25,000 of deductible losses that an individual can take against his ordinary income. Now, unfortunately, that $25,000 is a maximum. You can't take any more than your actual losses in any given year, which includes depreciation. But the bottom line is, if you're not a real estate professional and you're just an investor, you are going to have a limit of how much you can take as losses on your residential real estate that you operate. But that $25,000 maximum is reduced by 50 cents for every dollar that you have in adjustable gross income over $100,000. So that means if you have $100,001 of adjustable gross income, now you're limited to $24,900 and what did I do?
99.
And $99.50.
Yeah.
And by the time you have $150,000 of adjusted gross income, now you're not allowed to deduct in the current year against your ordinary income any of your operating losses. Now, they're not lost. They just get carried forward until the point in time that you sell the property. Then you can always take whatever losses that you've had. But the reason I mention that is if you've got an adjusted gross income of over $150,000, don't think you're going to be able to take depreciation expenses and other tax benefits until you get ready to sell the property.
Okay.
Now I'm going to talk very briefly about a general partnership. And sometimes we refer to this in Texas as a joint venture or a joint adventure. And all it means is that you got two individuals who are agreeing to own and operate property together. It's got some real problems, even beyond the problems that are caused by owning a property as an individual, because now not only are you liable for your own acts, but you can be liable for the acts of the other partner acting on behalf of the partnership. He might go out and borrow money or do business in the name of the partnership, and all of the partners are liable even though they didn't themselves make the agreement. So it In fact, it's amazing to think that accounting firms and law firms for so many years operated as partnerships because they subjected themselves to the liabilities of their other partners. And now you do have some right of contribution against the other partners if you have to pay more than your fair share of the liabilities, but that means you've now got to go sue your other partners and collect from them if they won't pony up their share. There's no cost to create or operate it other than the preparation of a filing of your typical income tax return, which is going to be a 1065 partnership return, and then the partnership is just an information return only. It calculates the income and taxable income and taxable losses, and then they flow through to the partners, and each partner gets a K-1 from the partnership that allocates their respective share of that taxable income and taxable losses. But one of the traps for the unwary is maybe the partnership doesn't actually distribute any income. That doesn't mean that they don't have taxable income. They may have taken the income from their operations and used it to, say, go buy a CD to use as collateral for the next deal. So there wasn't necessarily any cash that was distributed, and yet the partners who get K-1s that reflect their share of the taxable income are going to have to pay taxes on that income. So it's got some potential problems. Okay. You still have to file an assumed name certificate if you're going to use a name other than the legal name of the entity, and the legal name can be the joint venture or the names of the partners. But it's not unusual to see a joint venture that is named by the address of the property. Okay. It is probably the riskiest and the least attractive of all the entities to own property. If the title is in your joint names, even though for federal income tax purposes it's a partnership, unfortunately you may have the problem of what if one of the partners dies, one of the co-owners dies, and I don't have time to get into all that, but there are going to be problems if there is a tax problem or one of the partners dies or one of the partners files bankruptcy. You may find yourself in business with the heirs or the IRS or the bankruptcy trustee. So there are all kinds of problems associated with taking title in joint names or in partnerships. And interestingly enough, even though there are otherwise no franchise taxes owed if it's a partnership of individuals, if it's a partnership of something other than individuals, now you got to pay a franchise tax. So you haven't even escaped the franchise tax liability, and I'll talk a little bit about what that franchise tax is because it's imposed on virtually every entity other than a general partnership of individuals, certain trusts, and the individual. The IRS Form 1065 and K-1s to the partners I've mentioned previously. Now, what it may do that is important to some people may want to go out and associate with other people, and they're concerned that they may run into the regulation of the sale of securities if they're selling stock or interests in a limited partnership or in membership interest in an LLC. The standard in the securities law is generally that it's considered a security if there's an investment contract with an expectation of profits to be derived solely from the efforts of others. So one of the potential benefits of having a joint venture or general partnership is the argument that, hey, this isn't solely from the efforts of others, you're a partner. You have some involvement and control in the deal, and therefore it may be easier and better for you to raise equity capital by going to people who are going to also have some degree of control and who are going to be involved in the management and the operation of the property, and that may help you avoid securities regulation. Now, anytime you're going to be taking money from investors and they're not an accredited investor, they don't have at least $1 million net worth and a couple $100,000 of income for the previous 2 years, you better go see an attorney about whether or not you've got a securities regulation issue. Very quickly, the stock market crashes in '29. Congress comes along looking to see what was the problem, and they create a statute in 1933, the Securities Act, and then they create the Securities Exchange Act in 1934, and that regulates the sale of essentially pieces of paper or pieces of a business. And you have to comply with the securities laws or find some exemption why you shouldn't have to comply with the securities laws. And so virtually any situation in which you're trying to raise money from other people, you're going to have to look at the securities law issue.